The issue in this case is whether the presumptions created under Section 37A of Dangerous Drugs Act 1952 are against the concept of equality under Article 8 of the Federal Constitution. For the facts of the case, two separate trial judges charged both first and second appellant guilty of drug trafficking in violation of Section 39B1 of the Dangerous Drugs Act 1952. These appeals were heard together in the federal court because they were predicated on the same issue. On two different instances, the appellants received reprimands at the airport while travelling to Malaysia. The High Court found both appellants guilty as charged and sentenced them to death after observing that Section 37A2 of the DDA Act would permit the use of double presumptions, specifically that the presumptions under Section 37D3 and DA4 could be used together to prove possession and trafficking. Possession and knowledge, and then to prove trafficking. Both parties filed an appeal with the court on appeal, but it was denied. This appeal is the result. As for the principles used in this case, there are exceptions to the presumption of innocence. The public interest and an accused person's right must be balanced. To comply with Article 8.1, a statutory presumption in criminal law that sets the burden of proof on the accused must pass the proportionality test. The presumption's content and impact must be reasonable and not exceed what is required. The three stages of proportionality test. Firstly, the objective must be sufficiently important to justify restricting the right in question. The measure must have a rational access to the objective. The measure that violates the asserted right must be proportionate to the objective. And the factors that are pertinent to the proportionality assessment is whether the presumption relates to an essential or significant ingredient in the offence, and the opportunity for rebuttal, and the standard needed to disprove the presumption. The difficulty for the prosecution to prove the present fact. As for the judgment for this case, Section 37A of the DDA Act is unconstitutional for violating Article 5.1, which together with Article 8.1 of the Federal Constitution. Court convicted both appellants under Section 12.1 and punishable under Section 39A2 of the Dangerous Drugs Act. As for the ratio, the most severe consequence of applying a presumption upon a presumption is that the presumption of trafficking under Section 37DA is invoked using the presumed element of possession under Section 37D without taking into account that the element of possession in subsection 37DA requires a found possession rather than a deemed possession. This is essentially harsh and oppressive. Section 37A was legislated to facilitate the invocation of the two presumptions, yet there was no amendment to subsection 37DA. Invoking a presumption of trafficking based on proof of mere custody and control rather than proof of possession, as currently required by the subsection, would be a significant departure from the general rule that the prosecution must prove an accused person's guilt beyond a reasonable doubt.
The second case is a landmark case of Liehenberg against public prosecutor, which deals with the principle of equality under Article 8 of the Federal Constitution. Let's begin with the issue. The central question in this case was whether Section 498 of the Penal Code is inconsistent with Article 8 of the FC, which guarantees equality and therefore should be declared invalid. Moving on to the facts of the case, the appellant Liehenberg was charged under Section 498 of the Penal Code in the Magistrate Court. He challenged the constitutionality of this provision, arguing that it discriminates against women. Specifically, Section 498 only protects the husband's right to a peaceful and happy marriage by penalizing anyone who entices his wife away. However, it does not provide the same protection to wives against the enticement of their husbands. This, the appellant argued, treats women with indignity and inequality, violating Article 8 Clause 1 and Clause 2 of the Federal Constitution. Now, let's discuss the principle used in this case. The Federal Court emphasized the importance of gender equality as enshrined in Article 8 Clause 2 of the Constitution. The Court made it clear that any discrimination based solely on gender must be expressly authorized by the Constitution itself. The ratio decidendi was that Section 498 of the Penal Code unlawfully discriminates on the grounds of gender. It allowed only husbands to seek legal recourse for the enticement of their wives, while wives were excluded from similar protection. This constituted gender-based discrimination and violated the equality provision of the Constitution. Finally, in the judgment, the Federal Court ruled that Section 498 of the Penal Code violated Article 8 Clause 2 of the Federal Constitution, which expressly prohibits gender-based discrimination unless explicitly permitted by the Constitution. Even more, the discrimination was compounded by Section 132 of the Criminal Procedure Code, which restricted filing complaints under Section 498 exclusively to husbands. This procedural rule institutionalized the law's gender bias. The prosecution failed to identify any constitutional provision authorizing this gender-specific discrimination as required by Article 8 Clause 2. Without such authorization, the law's discriminatory framework could not stand. Therefore, the Federal Court declared Section 498 of the Penal Code unconstitutional. In summary, Laihenberg against PP is a significant case that reinforces the principle of gender equality and ensures that laws must not discriminate on the basis of gender unless explicitly allowed by the Constitution. Thank you. Moving forward to the next case.
Next, we will discuss a next key constitutional issue, whether Article 145 Clause 3 of the Federal Constitution, which grants the Attorney General discretion in prosecutions, breaches Article 8's guarantee of equality before the law. So let's break it down. So for the facts, the accused faced two charges under the Dangerous Drugs Act DDA 1952. The first one is dealing with 23.8 gram of heroin, and the second one is possessing 4.4 gram of morphine. So on appeal, the accused argued that splitting this issue into separate charges instead of combining them violate Article 5 and 8 of the Federal Constitution, claiming prejudice in prosecution. But does this discretion by the Attorney General truly breach equality under Article 8? So let's examine the court's reasoning. So the court clarified that Article 154 Clause 3 grants the Attorney General exclusive power to conduct prosecution as they think it fit. This discretion doesn't inherently violate Article 8, which ensures equality. Crucially, the court stressed that one constitutional provision, like Article 145 Clause 3, cannot defeat another like Article 8. Instead, Article 8 has a broader scope, so it doesn't restrict the AG's prosecutorial discretion unless there's a clear notice. There is clear malice or bias. So, for the judgment, the court dismissed the accused objection, upholding the charge by principle that under Article 145 Clause 3 and Section 376 of CBC, AG as a public prosecutor has full authority to decide the charges, and splitting charges is a lawful exercise of discretion under Article 145 Clause 3, not a violation of equality under Article 8. The court emphasized that Article 8 isn't breached unless there's proof of arbitrary or unfair on behalf of the prosecution. So for the conclusion, in summary, prosecutorial discretion under Article 145 Clause 3 is constitutional unless it is clearly abused. This case reaffirms the Attorney General's autonomy while balancing it with Article 8 safeguards. So thank you.
In the case of Muhammad Najib Abdul Razak and Government of Malaysia and another appeal, the issue is whether the inland and taxpayer are treated arbitrarily or unfairly as a result of Section 106 Clause 3 of the Income Tax 1967, which violates the Article 8 Clause 1 of the Federal Constitution. So the facts of the case is the Section 106 Clause 3 of the Income Tax Act 1967, or as ITA, was contested as unconstitutional by the appellants, which is Najib Razak and also the Muhammad Nasifuddin. So they claim that the revenue was unconstitutional under Article 8 Clause 1, which is protection under the law, and everyone is equal by the law. And particularly, they argued that the article actually was violated since the inland revenue was granted unrestricted authority, and which led to the discrepancy between the rights of taxpayers and also the inland revenue. So the principle in use, reasonable classification is permitted under the Article 8 Clause 1, which is provided that it is founded, the comprehensible and rational differentia, and also directly relates to the goal of the legislations. So the fair treatment within reasonable categories, not identical treatment, is what is meant by the equal protection under the law. Because of the Section 106 Clause 3 of the ITA itself, the justifiable legislative goal of tax collection without arbitrariness. It is past the Article Clause 1 constitution test actually. So the judgment, appeals were denied, and according to the court, there was no breach of Article 8, that ITA Section 106 Clause 3 is lawful according to the Article 8 itself. And the difference in authority between the IRB and the taxpayers was reasonable and justifiable and non-discriminatory. So the ratio decidendi in use is with the Article 8 Clause 1 as a two-part of test was used to determine the acceptable cost classification. First and foremost, the classification needs to be founded on identifiable difference, and second, the differential must make sense in relation to the status quo. So the court held that the IRB does not qualify as a person under Article 8. In tax enforcement, the IRB and the taxpayer were categorized according to administrative necessity and public interest rather than at random. So the goal of effective tax collection was logically fulfill the part pay first, dispute later arrangement.
Next, we shall have a look at the case of Letitia Bosman against BP. In this case, the issue is whether Article 145 or Clause 3 of the Federal Constitution, which give power to the Attorney General to conduct a case, has breached Article 8 of the Federal Constitution. The facts of the case includes, there are four appellants, namely, firstly, the first appeal is by Letitia Bosman, the second appeal is by George Crespo Gomez, the third appeal is by Benjamin William Hawkes, and the fourth appeal is by the Pubalan Sons of Paramount. Letitia Bosman, George Crespo Gomez, and Benjamin William Hawkes were separately charged, convicted, and sentenced to death by the High Court for trafficking in dangerous drugs, contrary to Section 39B of the Dangerous Drug Act 1952. Meanwhile, on the other hand, Pubalan Sons of Paramount was charged, convicted, and sentenced to death by the High Court for the offence of murder under Section 302 of the Penal Code. So, the principle that has been laid down in this case is that the judiciary is an independent body, that its duty is to only interpret the law and must apply the law that has been brought and enacted by the Parliament. Even if the law is harsh and against the social and moral value. This is due to the fact that the judiciary is in no position to question such laws, as they cannot be involved in matters of politics. The jurisdiction of the three branches of government must be respected by one another. The Federal Constitution must be upheld by the courts. Judges need to exercise self-control and resist the urge to intrude into the domains designated for other distinct branches, because maintaining the balance of Federal Constitution is very crucial. I shall pass to the next presenter.
For the judgment in the case of Letitia Bosman against public prosecutor, the judgment in this case was, the court held that the appeals about the constitutionality of the IPRUM provision was not valid and dismissed. Moving on to the ratio decidendi in this case, the power to determine such punishment is on the shoulder of the legislative body, which is the Parliament, because Parliament is the one who takes into consideration the social and moral values of the public, because parliamentarians are democratically elected and represent the will of the people. Furthermore, it is not the duty of the judiciary to determine whether such punishment is suitable or not for such offences, because the duty of the judiciary body is to be responsible for the resolution of disputes over the application or interpretation of the law only. Moreover, the reason why the Parliament imposed the punishment of death sentence for the drug trafficking, for instance, can be found in Dewan Rakyat Hansard dated 24th March 1983, in which it stated that drug trafficking was on the increase, causing social ills. Previous sentence was not a deterrent, and it had now become a threat to national security and resilience. It is a controversial matter of policy involving differing views on the moral and social issues involved, which is by its nature is more suitable for determination by Parliament than by the courts.
With you, there's no